Good morning, everyone, and thank you very much to everyone who's entered into the negotiations, which should make this process so much easier and possible for us to come to a conclusion. And that goes for both parties of objectors and the applicants, so thank you very much for that. As I'm sure you're very aware, this is a meeting of Gedling Borough Council's licensing committee to determine the application of 31 Plains Road, the old bank. I'm Councillor Paling. On my left, I have Councillor Nikki Brooks and Councillor Martin Smith. On my right, I have my legal support. I hope I don't need to have use of you, Laura, too much. And on the far right, we have people who are maintaining the feed system because this is being live streamed, at least in the first part. And I believe, are you taking the notes or is someone from membership services taking notes?
There'll be a minute, yes.
Yeah, there will be minutes. So thank you again. We've read the very large bundle of applications and objections. So I'm not sure now that we have the amendments how you're going to present your application, but would you like to commence by doing that?
Yes, good morning, Chair and Councillors, and Happy New Year. We have been, as you alluded to, some amendments proposed. Waiting for this to be.
Sorry, apologies. We just need to officially appoint the chair.
Oh, I'm sorry. Okay. We did it outside the meeting, but thank you very much. I've now been formally nominated as chair, but we did it a little while ago in the while we were waiting for you.
Declarations of interest.
And are there any declarations of interest? We have no declarations of interest from ourselves. Was I the only one there? Yeah, so I approved the minutes of the last meeting. Thank you. I haven't brought them with me. I can't get this open. There it is. So I will now ask you, everyone, I believe you've agreed a spokesperson to speak on behalf of the objectors. And of course, if any of you feel that the point that you really wanted to make hasn't been made, I will hear that. But we'll first of all hear from the applicant and then from the responsible authority if there's any more comment that needs to be made other than the fact that we've entered into the agreement. And I hope everybody will feel that they've had full opportunity for their say. So let's move on. If you'd like to present your case. Thank you.
Thank you very much. Yeah, I was going to say there have been amendments, but I will sort of refer to those as part and parcel of presenting my case to you today. I just wanted to check with you, first of all, you kindly said that you've had the bundle, but there were some emails that were circulated yesterday. Are you familiar with those? It just gives some background information to leading up to this hearing today. Okay, Chair, if I may, I'm going to start the presentation now on behalf of the applicant. And what I want to do in a nutshell at the outset is to set out what is our case. And that's this, that the application should be granted as applied for, subject only to the conditions which were volunteered in the operating schedule and also the additional conditions which you will have seen that have been agreed with the police, because there is no legal or evidential basis for refusing the application. And today you will hear a lot of information, but as you know, we can only do what is right in law for today's purposes and only take into account what is relevant and based on real substantiated evidence. And when I say right in law, I do of course mean the Licensing Act, the Statutory Guidance, your statement of licensing policy, as well as case law, but only where they are all consistent. Now, the issues in this case are very much straightforward, but I think it will be helpful for everybody in this room if I can just set out the background to the application and put it into some sort of perspective. The starting point, I would say, is to note that these premises are in an area where there's already a lot of commercial activity, which the resident will be used to, but there is no saturation policy in place. As part of the application process, as I've alluded to already, we liaised with the police and reached an agreement with them to alleviate their concerns, which also involved a lot of concerns regarding the residents. And as I say, an agreement on conditions was agreed, and you will no doubt agree that these were a very robust set of conditions to alleviate their concerns. And the applicant did this for one simple reason, and that is, of course, in the interest of working in partnership with the police who now support this application. Concessions were also made in relation to, with other representations in mind, for example, the representations from the environmental health officer as well as the residents. And it was for that reason, not only did we agree to amend the application so the hours were pulled back to 1 a.m., we also offered, or rather agreed, to restrict the use of the beer garden to 11 p.m. And that's when what we agreed with the police. We were not aware of the representations from the environmental health officer during the consultation period, and there's evidence of that in the emails that were submitted yesterday, and therefore we didn't have the same opportunity as we had with the police to come to some sort of agreement, and that's why we asked for an adjournment for those discussions to take place. There has been some discussions this morning, and in terms of the substantive part or the basis of the representation, the environmental health officer and I have agreed to disagree, but and that's a conversation for another day. It's academic for today's purposes because we have reached an agreement which alleviates their concerns, and therefore it's not necessary for us to address you on the mechanics of the representation, if you like. And the agreement is simply this: there will be no use of the beer garden. And that's not just for licensable activities, no use, full stop. So people can't ever go there. And that, we say, deals with the root cause concern of the environmental health officer, as expressed in their representation, which they will no doubt address you on, and we effectively have an agreement on that. So they're not formally withdrawing, but it's effectively a withdrawal of their representation on that point. Removing the beer garden, we say, also has the benefit of addressing many of the concerns of the residents, and you will have seen that in their objection. And what I will say about the resident objections is this, that it's quite encouraging, actually, to see that many of the residents generally support the development, that, you know, they don't want to derelict premises in their area, and only seem to be concerned with the initial hours that were applied for, as well as the concerns around the beer garden. And what we are hearing on the whole was that, you know, they wish to support the development, but the hours need to be in line with other premises. We took that on board, as I say, when we reached the agreement with the police. And I appreciate that some of the residents have highlighted the closing times for some of the surrounding premises. However, there is a difference between what is authorised on the premises licences of the surrounding premises and what those premises actually choose to operate. And it is, of course, the authorised hours which are relevant if a comparison is to be made. And many of the other premises, I believe, are authorised to operate around 1 p.m. and beyond in some cases, and certainly at the weekend. And therefore, the reduced hours agreed with the police, we say, were more than reasonable for a compromise to be achieved. And with regard to the beer garden, very quickly, you will have seen that some residents in their objection are actually happy to have a beer garden there till, I think it was 8 or 9 o'clock, but we've gone one better and said, no, we'll take it out completely. Again, this was done in an effort to work in partnership with the residents, and we believe that their concerns have been dealt with. By way of further assurance, we explained the applicant is investing substantial funds to create a high-end venue for the community, which we believe they will be proud of, and the applicant is keen to avoid these being, how can I say, the last venue to get a drink when others have closed. We're just simply looking for a level playing field in terms of the authorisation. This is not going to go beyond other premises. Therefore, what we say is the applicant has been reasonable in trying to accommodate the residents, and there have been further discussions today, and I'll touch on that a little bit later. And I want to emphasise that we're not here to dismiss the concerns of the residents, but we still have to do what's right in law and relevant for today's purposes. And we appreciate the licensing objectives are phrased using the words prevention, prevention of crime and disorder, etc. But the reality is we still have to do, we still need some real or substantiated evidence. Otherwise, it'll be impossible to grant any application to promote the licensing objectives. And we say this with the utmost respect to the residents, and we genuinely mean this, that the representations haven't, from a licensing perspective, been able to address the one and only, we say, question on evidence that matters, and that is whether there has been any real or substantiated evidence. We know that's obvious, but it still is a key question. Licensing, for better or for worse, is very much a suck it and see type of legislation, and that's what we have to deal with. The comments in the representations include matters, and you will have seen that yourself, which are largely irrelevant for today's purposes. For example, planning issues, parking, housing prices, demand for new premises, apartments which may or may not be built. And they do, as I say, suffer from lack of premises-specific evidence, or can be neatly packaged in a box called speculation, which simply is not enough to influence a licensing decision. Because to do so, in licensing terms, that will be unjustified, inappropriate, and disproportionate. We do have sympathy for the residents. We appreciate they're not experts in licensing. They are experts in their own area, if I can put it that way. But it is a balancing act, and we have to look at everything. And broadly speaking, that was the nature, maybe not to that extent, but that was the nature of the discussions we had with the spokesperson for the resident today. We said if we can avoid a hearing, yes, we will offer further concessions. We think we're justified in pursuing our case, but licensing is not about us against them. It's not about we win and you win. It's about striking that balance. And if we can move a little bit, we will do. So for the week, we suggested pulling the hours for licensable activities to 11:30, just as something more to give to the residents for making an effort to come today. We stick by our submission that, we're entitled, or there is no evidential basis or legal basis for refusing what we're asking for, but we want to get on with them. Certainly one member of the residents today is aware that the applicant actually lives in the area himself, so he is one of them, so to speak. High end, if you want to have more information about what it might look like or the necessary, I don't think it's necessary, but if you wanted that, the applicant is here today to answer those questions. So, to sort of wrap all that up, whichever way you look at this matter, and in the correct way from a licensing perspective, then the logical conclusion is to grant the application. And that is our opening. Thank you.
Thank you very much for that. Thank you. I'm going to ask Mr. Buttle, representing environmental health as a responsible authority, you have... Oh, sorry, do you have any questions from that? I don't have any questions. It was very thorough. Thank you.
Can I just ask one question? Sorry, you just mentioned during the week, 11:30. Can you just clarify the days of the week?
Oh, sorry, yes. All days except Friday.
Okay, thank you. Right, that's what I assumed, but I just wanted to ensure.
I assume that. I know that you've gone into the agreement about the garden, but are there any other points that you feel that need to be made?
No, I say our principal objection was the beer garden and the amount of noise that the premises is likely to generate. But so we have come to some agreement over that.
Right, so now I'd like to hear from your spokesperson for the objectors, if someone would like to say the things that are still perhaps outstanding in your mind, or are you now all happy that it's 11:30 in the week with the hours as initially requested, or are there other points that you feel that need to be made?
I think
I'll see
sorry. Yeah, I think the initial concern with everyone is that... sorry, I'm Mark Smalley. Mark Smalley. So I think the initial concern is that the licence application has been made on planning that has been submitted but hasn't yet been granted. So as residents, whatever licence is granted will be granted and we will live with. So the planning may change. The current owners may sell or lease those premises, and although their current intentions are for a high-end Italian restaurant, etc., and they don't intend to be the last bar open, we're going to be sort of bound by that licence, whatever may happen in the future.
I think the only thing I can say about whatever happens in the future, the licence will exist for the premises as requested if we approve it. But there is always the opportunity to call a licence in to review it if it is not meeting those standards or objectives that they have put in place. So it isn't the end of a matter if things do not seem to be going to that plan. Thank you. Does anyone else wish to... Thank you, sir. Your name?
Thank you. Bruce Roberts. Just a couple of points, one of them being that the applicant lives in the area. I'm not quite sure how broad that term is. I'm not sure the applicant actually lives in Mapley. I suspect they live in Woodthorpe or Sherwood, which is not quite in the area. West Ellie, there we go. Okay, right. And the other thing is that the start time for the licence hasn't been mentioned. The end time has. And so can we just have some clarification on the start time for the licence, because currently the application was for 8 a.m, I believe.
Do you want to answer that? Thank you.
We looked at the representation issues raised with the start time, and that's not part of the amendment. That is as it will be.
Thank you. So you're offering breakfast, potentially?
Absolutely.
Yeah, thank you.
And also, just to clarify one point, as things stand, as this hearing is progressing, the hours, the proposed hours are still 1 a.m. across the week, because we've not had an agreement on that. So depending how this pans, we will then address whether we'll be prepared to, if you see what I mean. There's not, 11:30 is not the starting point, still 1 a.m. As things stand.
I think it needs to be noted that many premises have licences quite either side of their official opening times on the shop door, as it were, and make their minds up almost on a rolling basis according to local need. And I do know that many premises aren't opening anywhere near as long as their previous times because of the pandemic. So, and it is flexible as long as you're operating within the parameters of the licence agreement. So thank you for that. I just need to check if there's anyone else wants to make any comment.
I'd like my comment, George Wildman. Although I have no evidence to bring to the panel, Friday and Saturday nights in Mapley is very noisy. And sometimes I'm a light sleeper, but a little bit older, I've difficulty going to sleep. It doesn't affect me that much because I'm retired. But there are people within the area that obviously are affected. During the week, I would hate to have a late night drinker with all the young children that are now coming into the area. That's just my point, is that it is not a quiet place at the weekends.
Well, thank you for the point, but it will not affect this licence application. And again, if we understand that the applicant is allowing unruly leaving of the premises later on, that can be questions at that point in time when we do have evidence, but it's not part of the application process. So it can be called later. Thank you. Has anyone else? Thank you. I don't know, the planning, that is a planning application, and perhaps when the application goes to planning, you might wish to make a comment about bifold doors and the possibility of the noise going out of the premises so that that can be controlled at planning application stage. Is that okay?
Opportunity to speak at the planning application stage of this?
I'm sorry, I didn't quite catch that.
Do we get a chance to meet when do we actually see the plans, the planning stage of it?
You get, the planning notice will be posted in the way that it usually is for planning, including putting it in the post. And you'll be able to read the application and make your representation by letter in the way that you have done today. Depending on the level of objections, it could be heard by a small committee, but it can also be brought to the main committee, which is a public meeting, where a representative would be allowed to speak about their objections. If it's deemed a very minor concern, it is heard by a small committee. Which is usually in private, but not because it's in private, because it's a weekly meeting that is held in the morning and very difficult to organise otherwise. So just to process things quickly. But if you make the representations, then it can certainly be heard in public if necessary. Does anyone else have any questions about that side of things? Is that okay?
Yeah, can I just ask, whilst this isn't a planning meeting, are there any comments regarding that, though, from the applicant that may be able to possibly allay fears?
The applicant representative who's dealing with that side of things, he's not here today either. But there is an application pending as we speak, and we do know that the planning officer has raised some points regarding noise, shall we say, which are being addressed. By way of further reassurance to the residents today, regardless of what's, and you already know this, regardless of what's decided today, that doesn't override planning, so they need to comply with everything. So, yeah.
Thank you. Yes, sir.
Hi, I'm Tom Price. I live on Bonington Road. I was just wondering, Tom Price. So it's you guys who are deciding on the application today. I just wanted to know if any of you have actually visited the site and seen how close it is to Bonington Road, to the houses. So you're well aware of, you know.
I personally regularly use Bonington Road car park
Oh, okay.
and the shopping centre, so yes,
Okay.
I believe
So, 1:30 kick out on a Sunday night.
I'm not
get
sure.
that, right?
I'm not sure that I've been there on a Sunday night, but I have been there on
No,
a
but
Friday
you can
night or
imagine
on a
if people are
Saturday.
spilling
Not
out
in
of
that
a-
particular car park. I usually
But
use
you
the
can
co-op
imagine
car
if people
park.
are spilling out of a bar at 1:30 a.m. on a Sunday night. You get that, right? You get it, yeah? Okay, good.
Hello there, Mark Vasey. I live on Gretton Road. It was mentioned earlier about Sunday through to Thursday night, and then the gentleman's just said he'd still like it to be 1 a.m. So from a resident's perspective, I think we'd all much prefer it to be agreed at 11:30 than 1, to give us some additional reassurance that things will be quieter during the week. I think I would also say that as residents, we're probably not fully prepared or used to these types of meetings, so it is quite disconcerting for us to sort of be stood out in the corridor, things being scurried backwards and forwards. So I, for one, would certainly much prefer it to be agreed upon formally in the meeting that it would be 11:30 than a 1 a.m. finish Sunday through Thursday.
My understanding is that is what you're putting forward, and that's what we will finally put into the licensing agreement.
Point.
Yes.
The first point is the legislation unfortunately doesn't allow for formal meetings. So the fact that we approached and engaged with the residents, that in itself is over and beyond what the legal requirements are. We wanted to work with them. We made an offer of 11:30, and we made that on the condition that if it's not accepted, we would come here and pursue our initial application. So, because otherwise there's no point reaching an agreement, is there? You can't have your cake and eat it. So it is what it is. As things progress, we may decide to amend that further, but we are pursuing the application as applied for, subject to the agreement with the police. Yeah.
Thank you. I think, yes, although you've had one go, I'll let you come back in, just to make sure we've heard
I'd just like
everything.
to follow up on that point that I object to the informal process by which we were met out in the corridor and given an option which would then be held legally accountable without it being formally written down.
It will be formally written down.
In advance.
Would you like to explain
Sure,
that?
certainly. The purpose and usually the benefit of being able to have discussions prior to the hearing is so that residents can, to see if there are conditions that can be brought that could then see the withdrawal of the representations. And in essence, if there's no representations, there's no formal necessity for a hearing. So it's always encouraged, because this is the only opportunity that you would get to speak to the applicant's representative and the applicant's solicitor, that if actually there are conditions that might help, and I think in this case, on looking at the majority of the objections, there were. The use of that beer garden. Sorry, Mr. Roberts.
It didn't form part of the brief that this would be the arrangement and we would be held to it.
No, you're not being held to anything.
We just had that told to us, that we should have agreed outside, and if we didn't, then things would be different.
It's not the applicant's decision, it's the panel's decision. What the applicant was saying was they offered some conditions that the objectors have not accepted all of them, and so their application, apart from the use of the beer garden, which has been agreed, remains as their application. Now, your objections still remain valid and are still that those opening hours are too late, and the panel have heard and have considered the objections as to why. So ultimately, the opening hours remained to the panel to decide. The negotiations prior to the hearing was purely in order to try and come to a compromise and an agreement, and that wasn't done by all. And so it's absolutely right that the application can be heard on the basis in which it was initially submitted. It's certainly not been done to try and get anybody to agree to something that they didn't want to, or make them feel that now, oh, actually we should have agreed. Ultimately, the decision is the panel's, and it was done purely in order to try and assist.
Will my objection be minuted?
There are notes that don't the matter's being streamed, is it, from a democratic services point of view? So.
We have certainly heard them, and it has been explained. It is us who make that decision, and will the final decision that we make will be binding, regardless of what the initial application said, because that's what we spent the morning doing, is trying to find that compromise that allows the applicant to run a business, but the residents to be as happy as can be about all the issues that you have raised. So I think, you know, we can say that we have heard your comments, and we'll make our judgments according to comments and the application. So it's time for summing up. Is there anything that you wish to say to sum up, or that you hasn't already been mentioned?
Do the residents want to, because it's normally the applicant that has the last word, so to speak, so is there a chance to, if they want to sum up, they...
Yeah, hi, it's Mark Smalley again. I think, on balance, we welcome development in the area. We certainly welcome the removal of the beer garden. We don't want a derelict old bank at the end of the road anymore. A nice restaurant would be great for us. It just needs to work with us, not have people leaving early hours of the morning. Although it's anecdotal evidence, Katie also witnessed New Year's Eve, there was a fight. Some of the guys came down our street. There was blood outside the applicant's premises. We don't want that happening all the time. We can say New Year's Eve, things get a bit crazy, that's okay. We don't want that all the time. We just want something sensible that works for everyone. And we feel an 11 p.m. Monday to Sunday finish, Friday, Saturday, maybe extended would be suitable, I think, on balance. We just want something that works for our area.
Thank you.
Thanks, Chair. I just want to sort of reflect on the agreements that have already been reached with the police, a very robust set of conditions, and what we've offered, we say, is in line with other premises, and also alleviate or should alleviate the concerns of the residents. I do want to make a point that sometimes in licensing, I don't think this is happening here, but sometimes in other parts of England, I see that it can be tempting to treat licensing as a numbers game, and the temptation can sometimes be to think that, well, if there's lots of people objecting, there must be a problem, but case law tells us there still needs to be some substance. So, for example, in mathematical terms, if there are 30 people objecting, but none of the objections amount to anything, and then that's effectively zero. There isn't a representation. And regardless of the number of residents objecting, we've already said the concerns are speculation-based. They suffer from matters which are irrelevant. And also, and this is crucial, they fail to take into account the balance that will be created by the conditions that have been volunteered in the operating schedule and agreed with the police. So for all those reasons, little weight should be given to those representations. And with regard to speculation about public nuisance, and I know you know this, but have the residents come to us with actual evidence which has been investigated, and there was evidence from the EHO to say, yes, there is a problem, only then could they say there is a noise nuisance which needs addressing. And because noise nuisance obviously is a two-stage process, first you need to have evidence of the nuisance, and only then can you move on to the second stage. And just in the final parts of the summing up, all we're asking you to do is to apply the Licensing Act, the Statutory Guidance, case law, and also the spirit of the licensing regime, and to come to the only conclusion, a logical conclusion, and that's to grant the application. I just also want to very quickly touch on the statutory guidance, which reminds us that beyond, and I quote, beyond the immediate area surrounding the premises, these are matters for the responsibility of individuals under the law. An individual who engages in antisocial behaviour is accountable in their own right. And the guidance also reminds us that the authority's decision, that's your decision, should be evidence-based, justified as being appropriate for the promotion of the licensing objectives. And finally, we also must take into account the principles of the High Court authority in Daniel Thwaites and Magistrates Court. I'm not going to go into too much detail because listening to yourself today, I can see you're already aware of these principles, but the court reminds us that the intention of the Act was to be permissive, and the High Court said it's impossible to predict what a new licence might bring, but the approach has to be to grant it, because the High Court said if there was ever a problem, there are safeguards in the legislation, such as reviews, closure powers, etc. And of course, there are also public and nuisance laws, which the Environmental Health Officer will know about, which can severely deal with premises if they do stray out of line. And you will know in your decision-making process following the Hope and Glory case that the licensing authority has to give full and clear reasons for their decisions, and they need to give compelling reasons if they depart from the principles as I've set those out. Those decisions need to be robust and stand up to scrutiny. And we say, the way we've set it out, the framework of licensing, if your condition falls, your decision falls in line with that, then your decision in licensing terms will stand up to scrutiny. Thank you, Chair.
Thank you very much. So we're going to withdraw for a few minutes to discuss our response to you all. We'll come back as quickly as we can. Shouldn't take us very long.
It might be a bit longer than a few minutes, Chair.
However, yeah, in terms of comparing it to the time that we spent allowing you to have the discussion. Do you want to make ask a quick question? Yes. Sorry? Thank you very much for waiting, everybody. Sorry it has taken so long. It wasn't the decision that took the time, but making sure we'd got it technically correct for the actual notice that will be published and the annual licence. We are going to approve the licence. However, we are going to impose conditions, and basically the conditions are on opening hours, plus the conditions that you've already agreed that we won't use the outside garden area at all. So Monday to Thursday, we're going to allow we're going to allow the opening hours as requested. Sunday to Thursday. It is Sunday to Thursday, isn't it? Yes, because, with a closing time of 23:30 hours, actual, this is wrong.
It's the activity, so you can serve alcohol till 11:30.
You can serve alcohol Monday to Thursday until 11:30 p.m. and actually close at midnight. And then Friday to Saturday, it will be 1 o'clock that you can serve alcohol till, actually closing the premises by 1:30. So we hope that those conditions actually make it possible for you to enjoy your area of residence, but you to be able to run your business efficiently. Okay, so there'll be a much more formal notice sent out to you once we've managed to type it all up, and that's breaking news coming to my computer. Something about COVID self-isolation changing yet again. So I think, unless you actually want to wait for the formal notice, everything is complete. So thank you very much for your time. And of course, the planning application is a matter of planning and will go forward separately when you're ready to submit that all. I don't think it's been received yet, but
Just to clarify, the decision notice will be sent, a copy will be sent to every interested party, and the application has been granted subject to the reduction in the opening hours and subject to the condition that that external area is not to be used at all.
That you adhere to the police conditions. The normal things are in there, but we needed to just make sure you could all go. We've been waiting long enough. Thank you very much.